Well, what we're going to do today is the basis of the entire law that we're going to study in the forthcoming weeks. We'll be studying different versions of international law, from law of sea to law of air, territory, and settlement of disputes, diplomatic law, and all of them are based upon certain sources. And you know what those sources are, right? Those 4 sources, you remember. And we have said that the first 2 of those sources that are, give me the names,
Treaties
and custom. Treaties and custom are the primary sources of international law. Therefore, we're going to study today the law of treaties. So how treaties are made, under what conditions are they valid, and when they become invalid. Well, actually, law of treaties. We also have law of contracts in municipal law. So we all roughly know how to make a contract, how to make a treaty, right? You know that there's a paper on which conditions are written and parties put signature on that. This is how we make our contracts. Who make contracts? You and me, we can do it, right? We are real persons. We have legal personality since birth till death. There are also legal personalities, as you know. State has its legal personality. Who else? Associations have their legal personalities. Companies have their legal personalities. So, they are the subjects of law. Those entities that I have mentioned, the state, all the institutions, associations, companies, firms, and so on, they're all known as subjects of law. But what I have mentioned are the subjects of municipal law. Then we have to discuss then who are the subjects of international law. Subjects of international law are states and international organizations, intergovernmental organizations. So, first of all, agreement is done in between subjects of law. State and state, state and IO, IO and IO. An agreement creates legal consequences. That's why you should never sign a blank paper, you know? Then it can be filled and you have to follow whatever is written on that. You know that there will be legal consequences. It creates duties and rights on the parties. There are obligations, rules, and rights. And when the parties put their signature on an agreement, they declare their consent to adopt all those rules, obligations, and enforcement of that treaty, if included. Treaty formation in international law as well is a formal method of making law. International law is made through international treaties. This is a direct method, it's direct evidence that there is law in that certain issue area. And making a treaty requires vast amount of time. Making an international treaty. And why treaties are so important? What do we do with treaties? With treaties, it's possible to acquire new lands, for instance. By treaties, it is possible to terminate wars. By treaties, we can establish intergovernmental organizations. Like UN is established by the UN Charter, right? So all organizations are established by an international treaty. Alliances are formed. The North Atlantic Pact, right? So, treaties are functional. At the moment, I call it treaty. In the Vienna Convention of the Law of Treaties, there you have seen that in International Court of Justice Statute, Article 38, Clause A says that international conventions are the sources of international. Convention, treaty, agreement, charter, status, protocol, act, memorandum of understanding, final act, covenant, pact, they all mean the same. And in legal language, they can be used interchangeably. So UN treaty, UN charter, UN agreement, they all mean the same thing. And treaties, law of treaties, that's governed by the Vienna Convention on the Law of Treaties. So this is the source of how to make treaties. And it has its own definition of what a treaty is. According to this agreement, an international agreement is done in between states. As you see, it excludes international organizations. It doesn't mention it. It's between states, it is written, and it is governed by international law. Those are the three main features that Vienna Convention on Law of Treaties 69 mentioned for us. There's another Vienna Convention which is formulated to enable treaties with intergovernmental organizations. It's prepared, signed, but it is still not put into enforcement, but it's already customary law. So this one, 69 agreement, entered into force in 1980. And this agreement says that all sovereign states possess the right to conclude treaties with each other. So states have that legal personality to sign treaties. This agreement, Vienna Convention, reflects the elements of the customary law on making treaties. So if we did not have this Vienna Convention, we could still know how to make an agreement. We could still move in the same way with all other states in how to prepare a treaty proposal, how to draft it, how to adopt a draft as a final text, how to open it to signature, how to sign it, when to adopt it, when do they terminate, how to withdraw from. They were all somehow known. All that knowledge is codified into this treaty. Therefore, this written treaty is already a customary law, which means something. Now, which country is here? I love map quizzes, by the way. Just keep in mind. Well, the green countries that you see on this map are those that have signed and ratified the Vienna Convention on Law of Treaties. The yellow ones are those that have just signed but did not ratify. And the red ones have never signed, ratified. The thing is that it is not so important at the moment if it is signed or not. What we know is that this treaty is already customary law, which means it is already binding on the states that did not sign the treaty as well. Therefore, this is a universal agreement. It doesn't matter if Turkey has signed it or not. It doesn't matter if United States ratified or not. We're all bound by this treaty already. Now we're talking about agreements that make international law. If you're studying diplomatic history, there you will come across with numerous agreements done in between leaders, which is known as gentleman's agreement, a little bit sexist perhaps. Gentleman's agreement, they talk to each other, they promise for certain conditions, they don't sign anything. Therefore, this promise is legally not binding. Although it's legally not binding, still It is an expression of political will that this promise can be turned into a written agreement. The most famous example of this kind of agreements is the Atlantic Charter that was concluded in between Roosevelt and Churchill in 1941. And this has laid the basis for the modern United Nations. Did you get the difference? This is just a verbal promise, and this is an expression of political will, and this is legally non-binding. No one has signed anything. Among international treaties, there are two different kinds. The first group is composed of the treaties that are concluded in between just two states, and they do not make international law. When Ukraine and Moldova make an agreement on their wine trade, it's only binding upon those two states, and it does not turn into international law. There's another group which is composed of multilateral treaties. Those multilateral treaties has a huge binding on numerous sovereign states. Those agreements can make international law. Those agreements make international law, actually. Not bilateral ones, the multilateral ones with, for most of the time, huge contribution. So it has many parties in that. First of all, in order to start an international treaty, we should know that there is a will to make an agreement on that certain issue area, what that issue area is. And once it is known, then the countries, states, somehow are in touch with each other and they start preparing a draft. Sometimes they form committees or conferences, summits, to bring experts together to draft the text. And sometimes one of the states take the lead and they formulate the draft. So first of all, a text has to be formulated. That text can be one single paper. That text can be composed of multiple texts. That's also possible, depending upon the issue area, the nature of that cooperation, so on. The thing is that who is going to prepare the draft? They can be the direct representatives of the state. Or if the issue is so technical, if it is legal, then specialized lawyers are invited. If it is about rivers, then specialized engineers are invited. So it depends. The thing is that they have to be authorized persons. So the state allows them to take part in the drafting process. And there are diverse methods, as I told you. Single state can do it, a conference can be established, there can be multiple working groups, there can be committees, depends. All of them are okay. Well, and then when the draft is finished, sometimes it is discussed for the last time to see if there are any objections. Sometimes there is a deadline. Because the discussions can last forever, there's a deadline, and until deadline the discussions continue, and the last modifications are done, and the final text is reached. And sometimes the preparing country does not consult with anyone. They just finish it and open it for signature. So it depends. It can also be voted. There can be a date for voting, and participant states can vote if they want to adopt this draft as the final text of the treaty or not. And after it is approved, authentication process starts. Authentication is signing. So what happens? The authorized people either sign it or put their initials. Well, they sound so as if they're easy details, because we never see a leader that is trying to put a Hello Kitty sticker instead of a signature, you know. Everybody knows that. And what if the leader cannot write and read? You know the system, right? You can put a thumb on it. That's also a possible method. Authentication is the first step of gaining bindingness. However, it is the first step for that, and it has to be continued by either a ratification process or by a referendum. Ratification is, we have already spoken about that, right? Did we? Ratification takes place in, well, we call it parliament for most of the time in this class, but by the authorized organ, by constitutional authorized organ, let's put it like that. There can be a Senate, House of Lords, House of Commons, whatever, whichever is authorized to ratify. It's happening like that. The leader, the representative, signs the treaty. What if the leader is a crazy guy? Well, a copy of that text is given to the parliament members. They read through it and they have to decide if this treaty is for the best interests of that nation or not. And then the voting takes place in the parliament. If they approve the text, it is ratified. Well, instead of asking it to the parliament members, it's also possible to ask it to the entire population, which is known as referendum. That's also another way of ratification. Any questions until here? Okay, yes?
What happens if there's a revolution in the country after they sign it?
What if?
There's a revolution.
I'll come to that then, okay? Before ratification, after ratification.
After ratification.
It remains. It still remains. Unless otherwise is declared by the new government. Yes, please.
With regard to Vienna Convention of the Law of Treaties, what was the situation for the treaty which was signed before this date, before this treaty, the Vienna Charter or
That's what I mean. Actually, even before this date, we know that no one was trying to draw funny comics instead of signing it. People were making treaties in the way we are talking about, actually. That was always like that. Vienna Convention has just codified this process. So, accession. Does anyone know what accession is? Accession is, first of all, parties come together, they sign it, they ratify it, they adopt and start implementing the treaty, and later a new state wants to be a party to that treaty. Turkey's accession to EU. Turkey wants to be a party member of the EU treaty, you know? That's known as accession. So accession takes place after the agreement is signed and ratified by the parties. The question is that, is it possible for each and every treaty? It depends. Depends upon the nature of the treaty. What we know is that, for instance, NATO is an exclusive treaty. I mean, what if Russia wants to be a party? They say, we need accession for NATO. What would happen? You know already how it works. So, or like Morocco trying to become a part of European Union. Makes sense. So, accession depends. Some agreements, their issue areas allow accession, and some agreements do not allow accession. For some agreements, if they're inclusive, sometimes those states that are already parties to that agreement has to vote if they really want the new member. And sometimes, like Genocide Convention, any state can anytime sign and ratify it because it is for the promotion of human rights, of course, all over the world. So no one discusses if we should add, well, Turkey is already a party, but shall we add Turkey to Genocide Convention? Or no one asks it. All nations are welcome. So it depends. Entry into force, when does the treaty enters into force? It depends as well. In some treaties, there is a deadline. And in some treaties, it calls for instance, it says at least 50 countries must ratify this treaty. After the 50 ratifies, then the agreement enters into force. So there can be a deadline, there can be a certain number of states that are supposed to ratify the agreement. After that, there are certain operations that have to take place. According to domestic law, after ratification takes place, then the text of that treaty is published. Where? In the official gazette. And promulgation takes place. It is announced that this treaty is adopted. And sometimes this new treaty requires new municipal laws as well. You sign an agreement related to environment, then you have to adopt new domestic policies, not policies, laws that prohibit, for instance, use of plastics. So sometimes certain domestic implementations are also necessary. Legal system of the subject state is also important. If that's a monist state, then the international treaty directly affects municipal law. If it's a dualist system, the state signs and ratifies the treaty, and later they have to adopt relevant domestic treaties to their parliament. That's a dualist system. And most of the systems are mixed, actually. Registration is an important step of treaty making. The registration takes place by the United Nations. When UN member states make agreement with each other, be it bilateral, be it multilateral, they send a copy of that text to the UN, to the Secretariat of the UN, and UN Secretariat gives it a number and registers it to its own records, and that agreement is added to their archives. Why is it necessary? First of all, UN is the most knowledgeable organ that we know all around the world. For instance, when two states are having certain disputes, then they're allowed to carry their issue to ICJ, and ICJ makes rulings. And the sources of ICJ are treaties, so they have to have the treaties in their archive. Secondly, United Nations is established for certain reasons, and the foremost of them is peace. Well, UN is trying to prevent states making secret agreements in between. If states are making secret agreements in between, then they cannot, of course, register it by the United Nations. And if any disputes arise in the aftermath, those states are not allowed to say that, well, we were behaving according to this treaty, now we come across with certain disputes, hey, UN, help us solving it out. No, UN says that if you have not registered that treaty, then you cannot come before any organ of the United Nations saying that we were bound with that treaty. And this is already codified within the UN Charter. So if it is not registered, then dispute settlement is not done according to that treaty. When does the agreement gains bindingness? It depends. Sometimes after signature and ratification, and sometimes there are some additional methods expected, depending upon the issue area or nature of that agreement. When is a treaty valid? When is it invalid? That's also important. A treaty is valid if all those steps that we have mentioned in accordance with Vienna Convention on Law of Treaties are followed. If those, you remember our example that instead of signing the treaty, sticking a Hello Kitty sticker, if it is done, you can simply say that it is not signed. It is invalid. We also said that representatives have to sign the treaty, either the natural representatives like the president, prime minister, minister of foreign affairs, and so on, or authorized people. So if a student has signed the treaty, then the person, we're citizens of our state, but we're not representatives of our state. So if a not representative person signs it, then the treaty is it's known as null and void actually. Anlaşma batıl olur. So the treaty becomes void. It is not existing. Well, if there is a mistake in the treaty, or if there is fraud in the treaty, which means we're trying to set our borders according to a treaty, and in the treaty, we have made geographical mistakes. We have mentioned a mountain that is not there actually in between those two states. Then the agreement is not valid. Or if one of the parties has given false data on purpose, then the agreement is not valid. And we have said that treaties are done through consent. Signature and ratification is a direct demonstration of sovereign states' consent. And use of force and to threaten to use force, they are not allowed in international law. So if the representative or the state are put under pressure through use of force or by threatening use of force, then the agreement does not reflect the consent of that state, and the agreement is, again, non-existent. As we were talking about the general principles of law, we have mentioned jus cogens principle. If the agreement reflects a violation, a jus cogens violation, then the agreement is null and void. Do you remember what jus cogens is? It says the limit is human rights violation. So a treaty can be in any issue area from finance to trade and banking and so on, but it cannot be about violating human rights. So, any questions until here? Treaties require interpretation. Interpretation does not mean translation. Well, translation is also necessary for some cases. What we mean here is, well, if you read through the UN Charter, you see that the sentences are quite understandable, quite clear. But once you start reading the agreements of IMF or the World Bank, then if the title is not there, probably you wouldn't understand that that treaty is about IMF or the World Bank. So some sentences are too complicated or ambiguous, unclear. Then specialists, scholars, the relevant people come together to interpret the treaty. That interpretation can be done commonly, can also be done separately, and there are certain principles while doing so. First of all, interpretation must remain in line with the context of that treaty. If the treaty is established in order to prevent use of nuclear weapons, the interpretation cannot include how to develop nuclear weapons, of course. So interpretation has to be done in good faith for the benefit of the entire parties of that agreement and in line again with the context of it. Interpretation sometimes requires politicians, sometimes requires legal specialists And if it's a technical issue, then, for instance, our example was about sharing the waters of a river, then we can also call engineers in to help us interpreting the treaty. Did you get? Is there anything that you need to clarify? And force majeure. Pacta sunt servanda. We have said that that's the basic principle of international law. And it means promises must be kept. Well, states keep their promises until force majeure. And when the state is hit by force majeure conditions, then they do not fulfill their obligations. They cannot follow the rules of the agreement anymore. And the state is not punished for their action. They're excused, actually, for what has happened. Acts of nature, acts of God, terror attack, war, self-defense conditions, countermeasure conditions. Under such conditions, if the state is violating their obligations or is not fulfilling their obligations anymore, that's completely okay. The treaty remains in effect. It does not terminate, of course. And the state starts fulfilling their obligations once again when force majeure is removed. And your question was, what happens if a revolution takes place in the country? What happens if diplomatic ties are cut off? Well, the general tendency says that actually the agreement remains in effect until otherwise is declared. Normally, borders are not flexible beings, as you know. And soldiers remain in their own borders. They can follow terrorists until the border, and they cannot go across. The terrorists are running across the border, the soldiers remain there. Under the leadership of Saddam, Turkey has concluded an agreement with Iraq which allows Turkish soldiers following terrorists into Iraqi territories. And then the Saddam government was not there anymore. The agreement remained in effect for a while. If I'm not mistaken, later, I have to look it up actually, but if I'm not mistaken, it is not in effect anymore because it's declared by the Iraqi state that they don't want to impose it anymore. But let me just look it up, what has happened, what the latest situations. But this is how it works. Could you follow everything? Reservation. Do you know Turkish word for reservation? Çekince. Now, there is a treaty text, and your state is willing to be a party to that treaty. However, there is one sentence that is conflicting with the national interests, or that sentence includes obligations that that state is not ready to fulfill, is not willing or is unable to fulfill. Then what happens? What happens is that the state is allowed to put reservation on that very clause, on that very article or sentence, that they are not willing to adopt only that sentence. The thing is that that sentence cannot be the essence of the entire agreement. The agreement is about nuclear non-proliferation, and the sentence says that non-nuclear states will not acquire nuclear bombs. And your state wants to put reservation. Yes, we want to be a party, but we don't accept that we won't adopt nuclear weapons. No, it cannot happen. That's the essence of the entire agreement. So, it should not be about the core of the agreement. Then states are allowed to put reservations. They put their signature or initials next to that sentence saying that we do not adopt this. We put reservation on this clause, on this sentence, on this article. We have two famous examples from Turkey. Does anyone know them? About migration and refugees. There are two conventions related to migration, and both of them are deciding or defining who a refugee is, who a migrant is, and so on. And Turkey has put geographical reservations on the definition of a refugee. So those coming from the eastern geography of Turkey can only become asylum seekers in Turkey. Those coming from the Western world can become refugees in Turkey. So in 1990s, we have seen a refugee influx from Bosnia, Serbia, and so on, Bulgaria. According to those reservations, those people coming from the Western world were allowed to become refugees. And those coming from the Eastern world, they remain as asylum seekers. So because of Turkey's geographical reservations. We'll go deep into that while we're studying law of migration, law of refugees. Well, reservation has advantages, disadvantages. It allows state to still be a party, to still cooperate with the others by just omitting one sentence, by omitting one obligation. That's fine. But it has also disadvantages because the text makes sense with its entire clauses, with its entire articles. So, the integrity of the treaty is somehow broken by a reservation, or all other partners bear all those obligations, but only your state. So we can discuss then if it's disputable, if it's okay or not. In bilateral agreements, reservation does not take place. If there are just two states making an agreement, and if one of them says that I'm not adopting this sentence, the other one says, okay, then I will also not. So they simply omit that sentence, omit that article or clause from the entire text. But in multilateral ones, reservations can be put by adding a signature and a small explanation next to the that very article. Did you get what it is? Do you have any questions about reservations? Termination, denunciation, or withdrawal. Well, on treaties, it's not so common actually, but there can be a deadline for the treaty. From 2023 on, this agreement will not be in effect anymore. Or the treaty can have a goal, like, what can that be? Like diminishing the carbon emissions. And if they fulfill this goal, then the treaty can be terminated. Or when suddenly the parties do not want to cooperate anymore in that issue area, then they can simply terminate the agreement with a common understanding. Withdrawal is so popular nowadays, especially by the United States. We hear it a lot that Trump, first of all, we have heard that they were willing to withdraw from that joint cooperation plan of action with Iran, from that agreement. US has withdrawn from UNESCO. What else? United Nations Human Rights Council. And they have threatened to withdraw from the World Trade Organization, from NAFTA. What? NATO? Well, they're saying that true, actually. They're saying that it is being a huge financial burden. So shall we terminate NATO? That's also happening. Newly, Qatar has withdrawn from an organization.
OECD. No, OPEC.
OPEC, that's true, from OPEC. And if I'm not mistaken, that was Nigeria that has that has been almost 1 year from 90 different organizations because of financial reasons. Because once you become a party to those organizations, you're also paying your dues and so on. So they have said that they don't have capacity for that anymore. So withdrawals are also, I'm not going deep into them here in this class, but actually according to Vienna Convention on Law of Treaties, if one state decides to withdraw from one treaty, then they're supposed to submit one written paper in 3 months in advance that they're going to withdraw. And sometimes agreements have their own withdrawal clauses, saying that if a state wants to withdraw from us, they have to tell us in 1 year in advance, for instance. They can have their own terms for that. If nothing is mentioned in the specific treaty, then we turn to Vienna Convention, then 3 months in advance, the state is expected to submit a written notification about their withdrawal decision. Until here, do you have any questions? If you don't have it, well, actually, I thought we wouldn't have time for that, so I didn't bring the copies. But in the next class, I'll submit you the EU-Turkish migration deal. Do you know what it is?
The readmission agreement about irregular
Give some details about that. You know what it is.
So in order to curb the flow of irregular migrants, Turkey and EU have a one-for-one policy in which for each irregular migrant sent from the EU back to Turkey, the EU will receive one Syrian migrant into the EU as a refugee.
Well, according... yes, please.
Was it also this one when EU promised us that if we get like certain number of refugees from Europe, they're gonna like cancel the visas?
That was a part of discussions. It was not like canceling visas, but it was about if you do so in the second tranche, then we can discuss about visa issue. True. Part of that discussion. That some funds, how much is that?
6 billion euros.
In the first tranche, it was promised 3 billion euros for Turkey. Actually, Turkey is not a country that is accepting refugees from the Eastern world. So Turkey is a country that is for trespassing only. And European countries have signed relevant treaties and they have promised to accept refugees. Turkey did not for the Eastern world. And at the moment, a huge number of asylum seekers remain in Turkey. And Turkey's gates are closed. They don't let those refugees or asylum seekers go further on to Europe. And if they make it, if they start swimming through Aegean, what happens? Then Greek police, they stop them, they hold them in the islands, and sometimes they give those refugees back to Turkey. Turkey is supposed to keep them in Turkey, and in return, Turkey is given 3 billion euros from the European Union to fund, well, not directly the government, but certain NGOs and different organs of the state, like the Ministry of Family and, I'm not sure, but different organs are given that money, and second tranche is coming at the moment. If you wish, you can already study this deal. What kind of a deal is that? If you don't study, I'll submit it to you on Monday. Then we can go through it according to law of treaties. And then I'll ask you some questions. Another good example for this study is Universal Declaration of Human Rights. You can also go through that to understand what kind of declaration, treaty, deal, what it is, plus Genocide Convention. So if you have some time, you can just search for the full texts, okay?